Good day, ladies and gentlemen. Joy Stephen from the Polinsys Studios. Here is a case law for the Student Herald. Aguirre versus Canada. Case laws are not meant for people interested to apply for immigration to Canada or permanent residence to Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog, reportersreport.com, as a PDF document. This is an immigration case, refugee status. It deals with procedure, designated representative. Refugee claimants AR and JR were mother and daughter, who were citizens of Mexico. AR was member of volleyball team that was attacked by gang members around 1997 or 1998. AR could not afford to pay gang members to avoid future harm, so she went to United States in 2001. AR entered into common law relationship with spouse who was also from Mexico. JR had been living with grandparents but joined mother in United States in 2006. AR, JR and spouse came to Canada in 2007 and commenced claims for refugee protection. AR had second daughter in 2008. Spouse returned to Mexico after AR made allegations of domestic abuse. In 2010, AR married husband who was Canadian citizen. Soon after, AR suffered debilitating stroke and was in coma. Designated representatives was appointed pursuant to S-167(2) of the Immigration and Refugee Protection Act of Canada. While AR was still in coma, Immigration and Refugee Board determined refugee claimants were neither convention refugees nor people in need of protection. Refugee claimants brought application for judicial review. Application was dismissed. Board's decision was neither procedurally unfair nor reasonable. Board recognized refugee claimants' circumstances and endeavored to ensure they had full opportunity to gather additional evidence and participate through their designated representative. Designated representative had been invited to make additional written submissions on state protection and had provided brief submissions. Board had concluded it could proceed with participation of designated representative and evidence on record and had not fettered its discretion by acting pursuant to board directive as alleged. Board considered all evidence and concluded refugee claimants had not established well-founded fear of persecution from either gang or spouse. Board was of view that upon return to Mexico, AR would be placed in a medical facility and JR would be placed with child care organization, both of which could provide or engage adequate state protection in Mexico. This was a reasonable approach given that AR's prognosis was that she would require long-term care. Refugee claimants' unfortunate circumstances could be raised in other applications. Aguirre versus Canada, another important refugee case, dated March 5th, 2015 from the Federal Court. Thank you.